Oh, I'm muted. I'm muted. Okay. Can you guys hear me? We'll go over all that. I'm reading some of your comments. There's a ruling, but we're gonna read that page last. I want to start from like the first page. So yeah, she's suing Lee County Sheriff's Office for those phone calls because, I mean, that makes the most sense. I mean, she can't go to phone. I mean, it would be hard to go straight to phone calls from prison when they're legally getting them from Lee County Sheriff's Office. So that would be, the route to go. But of course, it's not going to happen. You know what I'm saying? And I'll read through it and read their ruling on it and what they said and stuff. But yeah, interesting. So this is something totally different than those other two cases. This is a new case. It's not confidential. So this shows up. It's under a new one. So those other ones are still going on. I don't know what those other ones are between Jesse and Courtney. This is something totally different. So yeah, it's crazy. It's crazy, dude. I was going to take today off too. And then of course there's gotta be something. I was just going to take today off from Alive at least, and then I was like, no, I can't. We got to go over this. Sorry. I'm always putting chapstick on. I forget to put it on before I go, but all the reading I'm going to be doing. Okay. So yeah, there's going to be we're going to go through all the documents. There's 4 different documents. Does this light, so I was trying to see, my computer's over here, so it like puts a shadow on my face, which I like to have like a good lighting, especially I want to get this to light up more good, more good. But do you guys look, either this, is that light? I don't know. I'm trying to figure out. I'm still working on my perfect setup here. I'm not sure if I like that light here. Anyway, all right. So let me say hi to a couple of people while people are coming in. Hey, Susan. Hey, Sarah. Scooby. Dumpster. Oh, thanks, Storm. Thank you. Got Unity. I like it too. Anyway. Cry on the Moon. Hello. Hello, Dumpster. Hey, Storm. AZ. Da. Casey. Susan. Lost Gummies with AZT. Okay. Huh. Hey, Justice Jane. Hey, Tobeans. Nez, Olivia, Dumpster, Jackie, Nanya. Have you guys read this yet? How many people have already read these documents? Is there anybody already read them all? I've like skimmed through them because I wanted to do this early. So I didn't have time to like read. I just skimmed through them all. So there's probably going to be things that I didn't catch. So when I'm reading, it's probably going to be like I skimmed through them really quick, but I skimmed through the judgment because I wanted to see what the heck. But so yeah, you know how I do it. I like to read them with you for you. I like to like do things new with you guys, so it's like my first time, kind of. Hey, Cry on the Moon, Gigi. Okay, so let's do this. I'm gonna just start. Let me share my screen. Hold on, let me make sure. All right. Let me exit out of some of this stuff. Okay. I know I need to wear some of my merch, but I need to get my pay. That the reason I haven't been trying to like wearing it and trying to push it because I need to get that PayPal thing all figured out because that, how Printify. But yeah, you guys, the merch is really good. Sarah made it. Got the peeping ears and all right. Let's do this. Well, Jesse, not only she's got the 2 court cases with Courtney and Kelli, which we are not 100% sure what those are. We have some good educated guesses on what they could be. But now she's suing Lee County Sheriff's Office for those phone calls. Okay, so I'm going to read through. Oh, this is the first one. Okay. Hold on 1 second. All right. So this first page is kind of boring, but I'll just go through it really quick because I want to just go through everything at least a little bit here. So this is the civil cover sheet. Information contained in neither place nor supplement the filing service pleadings other than documents as required. This form must be filed by the plaintiff or petitioner with the clerk of court for the purpose of reporting the uniform data. So we have Jessica Tehonica and Wade Wilson. They're both plaintiffs. Versus Lee County Sheriff's Office, Office of the State Attorney, 20th Judicial Circuit defendant. Amount of claim, they don't have anything checked. Type of case, says if it fits more than one type of case, select the most definitive category. It says if the most descriptive label is a subcategory, is indented under a broader category, place an X on both the main category and subcategory lines. So they have checked other, and they didn't check a subcategory, which I'm thinking it would be, well, you'll see she's claiming that these phone calls caused her to have get threats, So, I mean, I guess it would be libel, but maybe that's why she didn't check which one. Because, I mean, libel and slander maybe, but then I don't know what that would be because, okay, she's claiming these calls made her get threats. What would that fall under? I mean, I think this would be one of them. I don't know. But anyway, so then we have remedy sought, non-monetary declaration. She doesn't want any money, it looks like. Non-monetary. Number of cases of actions, 2. So basically what she wants is she doesn't want no more calls being released. She wants that no more calls. I think that's what her end goal is, to be honest. But like I said, I only skimmed through these, so I'm going to learn with you guys. Is this case a class action lawsuit? No. Has notice of any other known related cases been filed? No. Is jury demanded in complaint? No. Does the case involve allegations of SA? No. So that's attorney or party. So that's her attorney, Andrea. Okay, so 2. So we got Jessica and Wade versus Lee County Sheriffs. Okay, this one we'll read here. Okay, so through the counsel, so it says the plaintiffs, Jessica and Wade, through counsel, sues the Lee County Sheriff's Office and the Office of the State Attorney for the 20th Judicial Circuit and alleges this action is brought to seek a declaration that the release of recorded telephone calls made by a pretrial detainee to friends and family members is not a public record subject to release as determined in Bent versus State. Plaintiffs seek emergency temporary injunctive relief to maintain the status quo and prevent any further release of recorded telephone calls. Additionally, plaintiff Tehonica has been the subject of multiple incidents of cyber intimidation in online social media forums due to the release of the recorded calls by the defendants. But in reality, it's because she lied. So it's not because the calls are being released, it's because she lied and her lies are becoming evident because of the calls. So in reality, that's, you know what I'm saying? It's not just because of the calls, it's because the lies. She's being caught in lies. That's what it really is. But I mean, I don't condone any freaking threats or anything, no. But I don't know what really has been happening. I'm not sure if she's saying it has. I don't know. I know people can be hard. I've gotten it. But okay, so plaintiff Jessica Tehonica is a resident of the state of Florida in Lee County. There you go. Remember, some people were saying no, she's in New York, or she doesn't. She is. So plaintiff Wade Wilson is currently incarcerated in Stark, Florida. The Lee County Sheriff's Office is an agency located in the 20th Judicial Circuit and a custodian of records, which is the subject of this lawsuit. The Office of the State Attorney for the 20th Judicial Circuit is a public agency that operates in Lee County and a custodian of records, which is the subject of this lawsuit. Jurisdiction and venue. This is an action seeking declaratory and injunctive relief, which this court has authority to adjudicate pursuant to Section 86.011 Florida statutes. Pursuant to statutes, venue is proper in Lee County because the subject matter of this action involves the release of certain records in the possession of and maintained by the LCSO and SAO in Lee County. Facts common to all counts. Wade Wilson was incarcerated at the Lee County Jail between November 2019 and September 2024 as a pretrial detainee. During the time of Mr. Wilson's pretrial detention, he frequently made telephone calls to friends and family members. Plaintiff Tehonica is one of the individuals Mr. Wilson would communicate with. The only form of telephonic communication available to Mr. Wilson to keep in contact with friends and family members was through the availability of a telephone maintained by the LCSO. Welcome to jail. And I mean, you don't murder people. Like you lose a lot of rights. LCSO recorded the telephone calls between Mr. Wilson and his friends and family members, including those of plaintiff Tehonica, the recorded calls. Over the course of the past several months, both the LCSO and SAO have received requests seeking access to the recorded calls. Specifically, the requests have come in the form of public records requests under Chapter 119 Florida statutes. The LCSO and SAO have already released certain recorded calls between Mr. Wilson, plaintiff Tehonica, and others in response to the record requests. Based on the information and belief, additional record requests have been made to LCSO, oh my God, why is that hard to say those letters fast as you're reading? Anyway, and SAO for the release of the recorded calls. I'm just going to say Lee County. Oh gosh, that's easier to say. Based on information and belief, the Lee County sheriffs and SAO plan on making additional releases of Mr. Wilson's recorded calls. The recorded calls of Mr. Wilson are not a public record within meaning of Section 119's Florida statutes. The 4th District Court of Appeal in Bent versus State granted a writ of certiorari quashing a trial court's decision allowing the release of telephone recordings of pretrial detainees. The 4th District held that the sound recordings do not constitute a public record subject to release. We agree with petitioners that the audio recordings of the defendant's phone calls are not public records subject to release. The 4th District Court of Appeal explained its rationale as follows. The sound recordings of inmate phone calls, which are not investigative material, do not perpetuate or formalize knowledge in connection with official action. If the contents of the phone calls do not actually involve criminal activity or a security breach, the recordings maintained by the sheriff's office are not material prepared in connection with official agency business, which is intended to perpetuate, communicate, or formalize knowledge. The recordings or petitioner's personal phone calls do not give the public access to information about the operations of a government agency. An inmate's personal phone calls do not in any way reflect the actions of government, and releasing the calls would not further the purpose of the Public Records Act. The recorded calls in the possession of the Lee County and SAO do not perpetuate or formalize knowledge in connection with the transaction of official agency business or of either agency. Because the recorded calls held by Lee County and SAO do not meet the definition of a public record, they cannot be released in response to requests made under the Chapter 119 Florida statutes. But they do because the prosecution pulled these for the case. They pulled them. Like they pulled a bunch of these phone calls, and then it'd be like that's usually when they pull them for a case. just because they don't use them, or it becomes a part of the case, like a part of the public record from what I understand. But I get they didn't end up having anything to do necessarily maybe with the case, but they pulled them for the case. Plaintiffs seek a declaration and emergency injunctive relief that enjoins the LSCO and SAO from any further release of the recorded cause. Plaintiffs have the right to privacy under Article 1, Section 23 of the Florida Constitution. Additionally, plaintiffs have the right to privacy under the 4th, 5th, and 9th Amendments to the United States Constitution. The release of the recorded calls has caused plaintiff Tehonica to be subjected to threats and harassment via online social media. See Exhibit A attached here too. The threats and harassment reasonably place plaintiff Tehonica in fear of bodily harm and constitute cyber intimidation in violation of a Florida statute. The continued release of the recorded calls violates plaintiff's rights to privacy under Article 1, Section 23, Florida Constitution, as well as the right to privacy under the 4th, 5th, and 9th Amendments to the United States Constitution. The continued release of the recorded calls between Mr. Wilson and the others, including plaintiff Tehonica, violates binding decisional law as established in Bent versus State. Without emergency injunctive relief, the continued release of the recorded calls would be contrary to binding decisional law, cause irreparable injury of the right to privacy, and leave plaintiffs without a remedy. Plaintiffs seek an emergency temporary injunction to maintain the status quo. The granting of emergency injunctive relief serves a valid public interest. Adherence to binding decisional law established in Bent versus State promotes a valid public interest. Additional protection of plaintiff's constitutional right to privacy and plaintiff Tehonica's rights to be free from cyber intimidation, harassment, and threats in violation of Florida statute promotes a valid public interest. But you can't blame something because people threatening it, and it's their own choice. Like, people that are threatening her have nothing to do with that in reality. You know what I'm saying? Like, that they can't be blamed, because let's think of another scenario where you could be like, well, because of that this happened, so you're at fault. No, it's go after the people that are threatening you, right? Really, Lee County's not. Plaintiffs reallege and incorporate by reference paragraphs 1 through 30 as if fully set forth herein. Plaintiffs seek declaratory judgment pursuant to Section 86, blah, blah, blah. An actual controversy exists between plaintiffs, the Lee County Sheriff's Office, and SAO regarding whether the recorded calls constitute a public record under Chapter 119. And the SAO is the attorney's office, the state attorney's office. So that's what that stands for if you guys are just coming in. So she's suing Lee County and the state attorney's office because they're the ones releasing it through. So, they're both, it's a chain. You know what I'm saying? So Lee County Sheriff's Office and the state attorney's office. Okay. Florida law provides that information held by a public agency is not automatically turned into public record simply because it is stored or possessed by a public agency. Further, the public statutory right to public records does not extinguish an individual's constitutional and statutory rights in private information. O'Boyle versus Town. Pursuant to the above cited authority in Article 1, Section 23 of the Florida Constitution, plaintiffs' privacy rights will be violated if the Lee County and the attorney's office continue to release the recorded cause under the guise that they constitute public records. Judicial intervention is necessary at this point to determine which, if any, of the recorded calls held by Lee County and the state attorney's office constitute public records under Florida law. Plaintiffs have no other adequate remedy at law. The dispute between plaintiffs, the Lee County Sheriff's Office, and the state attorney's office cannot be resolved without a judgment clarifying the applicability of Chapter 119 Florida statute as it relates to the recorded calls possessed by the Lee County and state's attorneys. I have to look up what's Chapter 119 that they keep saying. Wherefore, plaintiffs respectfully request this court enter judgment declaring that the recorded calls in the possession of Lee County do not constitute public records, cannot be released in response to requests made by Chapter 119, and grant any other relief that this court deems just and necessary. Here's count 2. So that was count 1. Let me take a sip of my water or my coffee. Why did I say water? Okay, count 2, temporary and permanent injunctive relief against the Lee County and state attorney. Plaintiffs reallege and incorporate by reference paragraphs 1 through 30 as if fully set forth herein. Plaintiffs seek an order enjoining the release of any and all of the above referenced recorded calls in the possession of the Lee County and the state attorney's office. The prior release of recorded calls has resulted in individuals in online social media forums making threats to plaintiff Tehonica and others. See declaration of plaintiff attached Exhibit A declaration, and there's a Exhibit B too. If the Lee County and the state attorney's office were to publicly release additional recorded calls in its possession that do not constitute public record, plaintiffs would have no adequate remedy at law and suffer irreparable harm, as the release of such information cannot be undone. The crazy thing is Jesse knows what she said in those calls coming up. She's probably freaking out. God knows what they talk about. There's probably going to be more lies and more scams. I don't know. But she's aware of them. She's freaking out. She's trying her best to get those stopped, right? I wonder what they say. There exists a substantial likelihood that plaintiffs will succeed on the merits of her claim under the binding decisional authority of Brent versus State. Telephone recordings of pretrial detainees do not constitute public records and are not subject to release. Entry of any injunction will serve a valid public interest by ensuring that binding decisional authority is adhered to. The recorded calls are private and do not constitute public records under the decision in Bent. Additionally, the public interest is served by the protection of constitutional rights of privacy. Notice has been given to Abby Jo Smith, Chief Legal Counsel for the Lee County Sheriff's Office, on Monday, September 16th, 2024, seeking voluntary cessation of any further release of Mr. Wilson's recorded telephone calls. See Exhibit C attached here too. To date, the undersigned has not received any response from Lee County Sheriff's Office. Notice has been given to Richard Montesalvo, Chief Assistant State Attorney for the State Attorney's Office, on Thursday, September 9th, 2024. See Exhibit D. At this time, no response has been received from the State Attorney's Office. Additionally, the undersigned certifies that a copy of this verified complaint has been served electronically on the Chief Legal Officer of Lee County Sheriff's Office and the Chief Assistant State Attorney for the State Attorney's Office. Wherefore, plaintiffs request this court enter an injunction of both temporary and after notice and hearing permanent, enjoining the Lee County and State Attorney's Office from releasing any additional recorded calls, and grant any other relief that this court deems just and necessary. And this is her lawyer here. Looks like, okay. And here is the exhibits. So we got Exhibit A, Declaration of a Jesse Tehonica. Jesse Tehonica declare and state as follows. I am over the age of 18 and have personal knowledge of the facts and matters stated herein. On Friday, September 13th, my identity was exposed online to thousands of people through the social media platform TikTok. Not only was my full name given out, but my phone number and P.O. box information. Wow, I didn't see that. I mean, I'm not saying it wasn't, but I haven't even seen anything that was given out. Did you guys? I did not know that. Anyway, since then, I have had my phone calls with Wade released online for thousands of people to listen to. While I understand these conversations were recorded, I never thought that they would be used to bully, harass, and intimidate me, instead for the security of the jail. These phone calls have been released through the YouTube account Phone Calls from Prison, and their main objective is to defame me and my character because of my beliefs and opinions to support Wade in his fight for justice. Since Friday, I have been relentlessly bullied online, received numerous threats, and have been consistently harassed through the social media platforms TikTok, YouTube, Instagram, and Facebook. These online threats have been made as comments on social media posts and direct messages on these social media platforms, including comments that people will be coming for me, making statements that you are done, and hiring someone to follow me and trying to identify where I work. There have also been online posts saying I have a death wish that implies someone is going to harm me. The above actions cause me to fear for my safety as well as the safety of my family, as their information has been threatened to be released to the public. These actions have given me a fear that I will be subjected to bodily harm. I am terrified every single day that I am going to be harmed when I am in public, and I do not want to leave my house. It says I do not want to even leave my house. This also has caused me substantial mental distress. Under penalties and perjury, I declare that I have read the foregoing and verified complaint for declaratory injunctive relief and that the facts stated are true. Okay. Declaration of Kelli Strom. Kelli Strom declare and state as follows. Wait a minute. Strom, that was, remember that one her last name was Strom, the one that was involved with Wade in the drug scam, right? Begins with a B. What was her first name? One of her last names she went by was Strom. Wonder if there's any relation. The one that we went through her records, you guys know what I'm talking about? She's the one that called Wade and did the drug stuff, set up the drug. Bonnie. Yeah, Bonnie. One of her, she had her maiden name and her married name. One of them was Strom. Yeah, but one, I'm pretty sure one was Strom, Wiggins. If I'm remembering right. I'll have to go back. One of the names, I think it was Bonnie's. One of her names was Strom. All right. Anyway, Kelli Strom, declare and state as follows. I am over the age of 18 and have personal knowledge of the facts and matters stated herein. I make this declaration in support of Jesse Tehonica for the purpose of providing evidence to the court. I am an active member of the U.S. Armed Forces. I am married with 2 children, and my husband has been aware of my contact with Mr. Wilson since it initially started and has fully supported my relationship with Ms. Tehonica and furthermore, Mr. Wilson. My contact with Mr. Wilson while detained in Lee County Jail started in late July 2024 and ended approximately 2 weeks later. This contact occurred after a friend who had already been speaking with him directed Mr. Wilson to me. I had been following Mr. Wilson's case since it started, and I am against the death penalty. I conducted my own research into Mr. Wilson's case and his trial, and out of good faith, my intent was to only assist his situation in support of him receiving the opportunity for an appeal with competent legal representation. I was not listed on his smart inmate messaging system until I had the first conversation with him. That was initiated by him contacting me via telephone after receiving my information from the aforementioned friend, and I did not correspond with him prior to that. Prior to this, I was involved in several social media groups centered around his case, where members were aware of my full name and the fact that I am in military. I deactivated my social media accounts in early August 2024, and I have not communicated with those individuals since then. Not long after speaking with Mr. Wilson, I was introduced to Miss Jessie Tehonica, with whom I have developed a very close relationship with throughout this process. Wait, did I misunderstand? Because I thought she said, well, I thought Jessie was the one that introduced her to Wade. I thought that was who hooked it up. I must have missed something. Anyway, didn't you guys get that? Hold on. Oh, I guess a friend. Never mind. I thought the friend was her. Okay, sorry. Oh, when she said aforementioned friend, I thought she was talking about Jessie. Okay, she was talking about somebody else. Okay, so she ended up meeting Jessie. You know, she's good friends with her. Okay, or close relationship. Since that time, I've remained in the background working on any kind of administrative support Ms. Tehonica needed. This was done to protect my identity as well as to remain a support system for Ms. Tehonica, as she has faced much public scrutiny for her role in advocating for him. Again, I have not had any personal social media accounts for quite some time, and my personal information has been removed from the majority of data broker websites. I was made aware of the statements made by the state attorney's office after Mr. Wilson's sentencing that they had copies of calls, messages, names, places of employment, and personal information. It wasn't until Friday the 13th of September 2024 when Ms. Tehonica's personal information was broadcast on multiple social media accounts that this became a threat to me. People associated with Ms. Tehonica have now been threatened to be doxxed, exposed via Reddit, TikTok, and other social media forums. My name in particular was referenced from a TikTok account, and that was on Friday the 13th, September 2024. The specific statement was, "Is this Kelli from Team Wade? And Kelli, I'm about to expose you." From the YouTube content creator podcast YouTube Streets. Oh, my name's in there too. Oh, look down here. Via this TikTok account. Furthermore, I was notified by Ms. Tehonica on September that a call between Mr. Wilson and I was scheduled to be released via the phone calls from prison, which is then usually taken and replayed via the following YouTube channels: Jumpsuit Pablo, Zavgirl, YouTube Streets. Has there been one from Kelli yet? I don't remember a phone call from Kelli. Remind me. Has there? I don't know. So wait, what date was this? September 18th, 2024. What is today's date? September 23rd. Okay. I have personally seen several of these comments, including those threatening Ms. Tehonica, on websites that are accessible without needing a social media account. Perplexed. I don't even play very many of the phone calls. That's funny. I've only played it probably I think I've played 3 different times. I'm not one of the ones that play them a lot, but it's okay. I have personally seen several of these comments, including those threatening Ms. Tehonica, on websites that are accessible without needing a social media account. But has Kelli, because I missed it, has Kelli calls been released? I don't know. I haven't even checked if any new calls have been released in the last day or two. All right. The imminent risk to me and my family's safety does not escape me based on the public's continued harassment and threats to Ms. Tehonica and others who have been on the other side of these calls that have been released since on about the 1st of August. Based on the threatening and harassing online comments, I have a reasonable fear that I and or my family will be subjected to bodily harm by the individuals posting the threatening and harassing comments online. I reasonably fear that the release of any identifying information in connection with making this declaration in support of providing evidence to Ms. Tehonica in connection with this legal proceeding will further expose me and my family to continued harassment and threats. I also reasonably fear that making this declaration in support of providing evidence to Ms. Tehonica would cause substantial injury to me and my immediate family based on the nature of the online comments that are threatening and harassing. Under penalties of perjury, I declare. Okay, so now we have Abby Jo Smith, Chief Legal Officer. Dear Miss Smith. I want to see who this is from. Oh yeah, Andrea. So this is from, I think this would be her lawyer, right? Okay. Dear Miss Smith, greetings. I represent Wade Wilson, who was previously incarcerated at the Lee County Sheriff's Office. It has come to our attention that the Lee County Sheriff's Office has released personal calls made by my client to friends and family members. We reasonably believe that the Sheriff's Office plans to release additional calls made by my client. We believe that the decision in Bent versus State applies and precludes the Sheriff's Office from releasing these calls as a public record. In that decision, the 4th District Court of Appeals held as follows. The sound recordings of the inmate phone calls, which are not investigative material, do not perpetuate or formalize knowledge in connection with official action. If the contents of the phone calls do not actually involve criminal activity or a security breach, the recordings maintained by the sheriff's office are not material prepared in connection with official agency business, which is intended to perpetuate, communicate, or formalize knowledge. The recordings of petitioners' personal phone calls do not give the public access to information about the operations of the government agency. An inmate's personal phone calls do not in any way reflect the actions of government, and releasing the calls would not further the purpose of the Public Records Act. We respectfully request that the sheriff's office immediately cease and desist from any further release of my client's phone calls. Alternatively, if you disagree with the decision and bet, please advise us immediately, in which case it is my intention to seek injunctive relief on an expedited basis in the circuit court for the 20th Judicial Circuit to maintain the status quo. So that's Andrea Flynn. So that's who's releasing. Okay. Thanks, Lexi. I wasn't sure because I haven't checked phone calls from prison in a couple of days. So I wasn't sure if they were released anything recently. I've been too busy with this stuff. All right. Now this is to Richard. Who's this from? I like to see who they're from. Oh, this is from the lawyer too. Okay. Richard Montesalvo. Dear Mr. Montesalvo, greetings. I represent Jessica Tehonica and Wade Wilson. It has come to our attention that your agency has released personal calls made to Ms. Tehonica by Wade Wilson, an individual previously incarcerated at the Lee County Jail. We reasonably believe that your agency plans to release additional calls made to and from my clients. And then it's the same thing. I'm not going to reread this. Or wait, is this? Yeah, it's the same thing. She talks about how it doesn't show the government's actions, so it shouldn't be public record. Okay, anyway. And then she writes, yeah, same thing, just repeating the stuff. Okay, so we got that, and now we got, let me take a sip of this. All right. Well, you know what? They're probably going to argue that it's for Wade too. I bet you, because it's Wade's a plaintiff too. I'm not saying it's right, but I'm saying that's probably how they would argue. If they are using the money, they would say, well, this is for Wade too. But still, I'm sure that's not the reason why people were donating, right? They're donating to get the appeal. So yeah, it's still okay. So motion to determine confidentiality of court records. Plaintiffs, through counsel and pursuant to Florida, blah, 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 seeks the entry of an order determining the confidentiality of court records and support. Plaintiffs would show as follows. Plaintiffs seek to redact identifying information from a declaration of a witness who is the subject of threats and harassment via online social media forums. As set forth in the declaration attached Exhibit A, the witness seeks to provide the court with evidence in support of plaintiff's claims. Wait. Okay, so they're talking about like these records, right? To keep them confidential or redact things. Okay. Is that what it is? I didn't really read this one too much. Okay. However, the witness is deeply concerned about sharing identifying information due to the ongoing threats and harassment happening on social media platforms targeted at the witness, plaintiff Tehonica, and others. As set forth in the declaration, the witness reasonably fears bodily harm and cyber intimidation by publication and violation of the Florida statute, which includes the act of electronically publishing information to an internet site or forum for the purpose of threatening or harassing a person, placing such a person in reasonable fear of bodily harm. But see, that's not the purpose. Like phone calls from prison, that's not the purpose of they're releasing the calls. It's to hear Wade. And plus, this is like a big thing. People are donating to this cause, right? And it's like exposing what what this cause is and what really is going on. Like, there's no way that you'd be able to prove that she was doing it to incite threatening, because she wasn't. Never once did any of us. I'm sure you haven't YouTube streets. I haven't watched your stuff recently, but like, I'm always like, no threatening, don't go real life. I never know real life. Like, so, I mean, some people do. I'm sure there are some creators or accounts that are doing that, but the ones they're naming aren't, you know? The declaration of the witness who is the subject of this motion is vitally important to obtain evidence to determine legal issues in this case, and is therefore confidential under Florida statute. Without the ability to redact identifying information in the proposed declaration, plaintiffs would not have the ability to obtain evidence necessary to determine legal issues in the case. Additionally, redaction of identifying information in the proposed declaration will avoid substantial injury to innocent third parties. The witness is not a party to this case. And let me just back up again. So phone calls from prison never released any names. They just released the phone calls. It was because of her cease and desist that her name came out. Like, she exposed herself. You know what I'm saying? So nobody would even have known. I mean, maybe Reddit, you know how they do it. Maybe they would have found out anyway, but it was because her cease and desist had her whole name on it. And then in those phone calls, you heard Wade say Jesse, but like, phone calls from prison didn't say this is a phone call from Wade. And they've never released who the names were, like the full names. Yeah, they do. And I've had to do it, you know, where as creators, you do have to do that kind of stuff. Like when I got the Paul jail calls, I had to redact some names and information too. I mean, us creators, responsible ones, have to do that. But it was like, yeah, phone calls from prison is not the issue. I mean, there are some people that are issues that would threaten and stuff. Those are the people that are the issues, the ones that are doing the threats. Like, I'm always like, do not go real life. Please, guys, don't. Just leave them alone. We just want to learn about these cases. And like, at least me, I just want to learn about it. I'm very curious person. I want to know everything. I would never dare go real life and call or threatening her or go to her work, or people call works. They just do all kinds of stuff. But I think she's going after the wrong people. You know, go after the people that are making the threats. Find out who's threatening you and go after them then, right? I'm not saying she would win, but I mean, you're going after people that aren't doing anything but covering we're reporting on a case. Like, this is a big case. We're like reporting on this case that's going on. Oh, I know, YouTube Steve. We have the order. I'm going to go to that next right here. Yeah, I know. They say we'll get to that. Anyway, I just wanted to go in order. All right. So, where are we at? Where are we at? I forget where I left off, guys. Okay. Additionally, redaction of identifying information in the proposed declaration will avoid substantial injury to innocent third parties. The witness is not a party to this case. However, individuals associated with plaintiffs are currently subject of cyber intimidation efforts via online social media forums, which include conduct that constitutes threats and harassment within the meaning. These actions place the witness in reasonable fear of bodily harm. Specifically, this motion seeks to redact from public disclosure all information in the declaration that would reveal any identifying information of the witness. Attached Exhibit B is a copy of the declaration of the witness containing proposed redactions. Plaintiffs also seek to redact identifying initials of the witness in paragraph 42 of the verified complaint, and the declaration attached as Exhibit B to the same. The redaction of identifying information in the declaration and verified complaint is no broader than necessary to protect the interests set forth in Rule blah, blah, blah. Okay. There are no less restrictive measures available to protect the interests set forth in Rule 2.42, blah, blah, blah. I hate reading all. I'm not going to read all these numbers and letters. This motion does not seek to close the court file, the progress docket, or the identify of the parties. Certification of good faith. Okay, let's see. So they're saying they'll file the foregoing with the clerk of court and served electronically to Abby Joe and blah, blah, blah. Okay. This is the same. I think it's going to be the same. Yeah, this is the same letter. They just attached the same exhibits. See if there's anything new, though. This one, they have this one. Let me see. Is this a new one? This one's redacted, but I don't. Declaration of blank. Blank declare and state as follows. I'm over the age of 18, have personal knowledge of the facts and matters stated herein. I make the declaration in support of Jesse Tehonica for the purpose of providing evidence to the court. This is all redacted. With Mr. Wilson, since it initially started and has fully supported my relationship with Ms. Tehonica and furthermore, Mr. Wilson. My contact with Mr. Wilson while detained in Lee County, some redactions. It says this contact occurred, some redactions. I had been following Mr. Wilson's case since it started, and I am against the death penalty. I conducted my own research into Mr. Wilson's case and his trial, and out of good faith, my intent was to only assist his situation in support of him receiving the opportunity for an appeal with competent legal representation. Oh, this is the same one, but on the first document it wasn't redacted, and then this one is. Yeah. Yeah, it's the same one, but we already read one. It was not redacted. Wonder why they have. Anyway, all right. Oh, thank you, Michelle. Thank you so much. Sorry, I'm not able. I'll be in chat in a minute. I just want to read these to you. I'll say hi to everybody. But thank you so much. You rock. You rock. Wait, did I miss another one? Oh, no. Okay. All right, so here we go. Respondents' answer to verified emergency motion for temporary injunction. So comes now, well, let me make it one more bigger. There we go. Comes now, the respondent, Lee County Sheriff's Office, by and through undersigned counsel, and hereby responds to move-in's verified emergency motion for temporary injunction, and in support thereof, state as follows. Introduction. The respondent denies that the move-ins are entitled to the relief requested in the verified emergency motion for temporary injunction. The move-ins have failed to meet the necessary burden to obtain such extraordinary relief. Failure to satisfy requirements for injunction. In order for an injunction to be granted, the plaintiff must demonstrate the following: irreparable harm. The movement has failed to demonstrate any irreparable harm warranting the issuance of an injunction. To justify such relief, there must be concrete evidence of immediate and significant harm, not mere speculation or unsupported allegations. Clear, definite, and unequivocally sufficient factual findings must support each of their 4 criteria for entry of temporary injunction. However, the movement offers no such evidence. In paragraph 12 of the verified emergency motion for temporary injunction, the movement claims that Lee County and the state's attorney's office have already released certain recorded calls between Mr. Wilson and the plaintiff and others in response to the record requests. However, after a thorough review by Lee County Sheriff's public records units and social media platforms managed by Lee County Sheriff's Office, no evidence has been found to indicate the release of any such calls by Lee County Sheriff's Office, except through standard investigative and prosecutorial channels, for which Lee County remains responsible under the law. It is apparent that any publicized calls involving the movements were shared by third parties over whom Lee County has no control. This undermines the assertion that Lee County is responsible for these releases. Further, in paragraphs 13 and 14, the movement state, based on information and belief, additional record requests have been made by Lee County and State's Attorney's Office for release of recorded calls. And based on information and belief that Lee County and the State Attorney's Office plan on making additional releases of Mr. Wilson's recorded calls, these statements rely solely on belief and fail to provide any substantial evidence or information to support these claims. The vague and unsupported nature of these allegations cannot justify emergency injunctive relief. Moreover, in paragraph 29, the movement argues that plaintiffs' privacy rights will be violated if Lee County and the State's Attorney Office continue to release the recorded calls under the guise that they constitute public records. And thank you, Zawalski. Okay, yeah, we could do that. Sorry, I've been so busy lately. I got to get back to so many emails, but thank you. I'll get back to you. Just give me a little bit. Thank you. Sorry, I'm just reading some chat. All right. Moreover, in paragraph 29, the movement argues that plaintiffs' privacy rights will. I already read that, huh? Okay, so there's no. It says violated if they release the calls under the guise that they constitute public record. Yet there has been no evidence of any release by Lee County or response to the numerous public records requests received by Lee County. Movement's speculative fear of future harm is insufficient to establish irreparable harm. The movement also contend in paragraph 32 that the prior release of recorded calls has resulted in individuals in online social media forums making threats to and harassment of movement Tehonica and others. However, it is not the responsibility of Lee County to regulate or police the behavior of individuals participating in public forums. To hold Lee County accountable for the speech of private citizens in online spaces would present serious constitutional concerns. Importantly, the movements have provided no proof of any specific threats or harassment. Movements further claim to fear bodily harm in violation of Florida statute. However, as Lee County has had no involvement in the release of these calls, it cannot be held responsible for any subsequent events arising from those releases. The movement cannot claim a violation of privacy rights when they voluntarily expose their name and information by participating in public forums and support groups. There you go. Likelihood of success on the merits. The movement's likelihood of success on the merits are exceedingly low. The central argument revolves around the claim that the recorded phone calls should not be considered public records. However, Florida Statute 119 clearly identifies these calls as public records, subject to exemption for active criminal intelligence or active criminal investigative information. As movement Mr. Wilson's case is currently under appeal and involves an ongoing investigation, the calls fall squarely within this statutory exemption. The movement's reliance on a single insufficiently analogous case does not alter the fact that these recordings qualify as public records. Nor does it support their argument for withholding disclosure. Adequacy of legal remedies. Adequate legal remedies are available to the movements, which further diminishes the need for an injunction. Injunctive relief is an extraordinary remedy, appropriate only when there is no adequate remedy at law. Here, the movements have legal avenues to pursue against the actual parties involved in alleged wrongdoing, namely third parties who may have released the calls, not Lee County. This underscores the lack of necessity for injunctive relief. Public interest considerations. Contrary to the movement's claims, granting this emergency motion would harm rather than serve the public interest. Providing judicial remedies in response to speculative claims would set a dangerous precedent by shielding individuals from the consequences of their own voluntary actions. Participation in public forums and support groups does not entitle one to the immunity from public disclosure or public discourse. No immediate threat justifying emergency relief. Declaration of Movement Tehonica. In declaration, Movement Tehonica alleges that phone calls involving her were posted on YouTube through the Phone Calls from Prison channel. However, no specific videos or calls were referenced or provided, and there's no evidence connecting Lee County to this release. And Movement Tehonica fails to show any involvement by Lee County. Moreover, her assertion that these actions were intended to defame her is unsupported by any tangible evidence. That's the thing. That's the thing that doesn't make sense, because how, I don't think that that proves that it was to defame her. You know what I'm saying? That's what I was saying. I know, right, Granny? Probably. Declaration of Kelli Storm. This one says Storm. That other one says Strom. So I don't know. Didn't it, or did I read it wrong? I swear it said Strom. Mrs. Storm similarly states that her participation in social media groups led to her personal information being shared publicly. I've never even heard of her, but I mean, some of you guys have. I didn't even hear of Kelli Storm or Storm. This is the first I'm hearing of her. Yet, by her own admission, she voluntarily engaged in these groups and provided identifying details. The decision to participate in public discourse carries inherent risks, including criticism and exposure. Again, there is no evidence linking Lee County to any wrongdoing. Mrs. Storm's additional claims of immediate danger are based on speculative fears, not actual threats, and do not rise to the level of irreparable harm that would support injunctive relief. Despite sending a cease and desist letter to Lee County, oh my God, so she's on September 16th, 2024, movements filed this motion without awaiting a response or engaging in further communication. Filing on the last business day before a weekend, without affording Lee County or the state's attorney's office a reasonable opportunity to respond, casts further doubt on the urgency and legitimacy of the movement's claims of irreparable harm. Under rule of civil procedure, temporary injunction must specify clear grounds for relief and describe in detail the actions to be restrained. The movements have failed to demonstrate Lee County's involvement in any alleged wrongdoing, and as such, there are no actions for Lee County to be adjoined from performing. There we go, sorry. For the foregoing reasons, the respondent respectfully requests that this honorable court deny a movement's verified emergencies motion for temporary injunction and grant any other relief that the court deems just and proper. I wonder what hold on one second, guys. I wonder what Prison Calls is thinking. I should email her. Wonder if what's going on, if anybody contacted her. How you guys doing? Oh, I guess it's not there. Hold on a second. I thought there was another one. Yeah, the other one did say Kelli Strom, though. So I don't know if it's Storm or Strom. Look. Where is it at? Yeah, I don't know. You know how these documents have typos in them all the time. They do. Just because they're court documents does not mean they're free from mistakes. We learned that. Um, Yay, you got it. That's all I have, really. I'm gonna keep this a short live. I just wanted, because I wasn't even gonna do a live today, but I just wanted to, I saw that. I'm like, I got to. So I don't know. I don't know what's gonna happen. I'm still trying to figure out the whole Kelli Matthews and Courtney thing. I might work on that after I end this, actually, see if I can find anything. But I don't know. I probably not. It's confidential. I probably won't be able to. But let me say hi to a few guys here. Hey, KFC. Lewis in the house. Hey, Melissa. Moira. Hey, Susan. Let me check my emails real quick. Make sure I'm not missing anything. Give me 1 minute. Sometimes I get some good stuff through emails. 1 second. What's this? Give me 1 minute. I'm just going through them. I just want to make sure, because I don't want to like end the live and then I get something and I'm like, oh shoot. Oh no. All right. I don't know. Yeah, I guess that's it. There's nothing. Everybody was just talking about this on my emails. So, well, thanks, Sarah. I think I am going to reach out to phone calls from prison. Oh, yeah. I just don't understand. Like, go to the people that are making the threats. You know what I'm saying? I mean, it's still going to be hard. That's still hard, like that kind of thing, because it's just hard to prove. Like, I don't know. I think it would be hard, but like I feel like that's who you probably should go after if people are really like threatening you, right? I don't know. I mean, that's the people that are threatening you. I I mean, I got it too. I know it could be, it did. I mean, it's crazy. It gets a lot. Like when I went through my stuff, oh my God, I had people threatening my life, my family's life, talking about killing my mom, talking about, I don't know if I could say bomb, like, I don't know. I don't want to BOMB me. um, my house, talking about coming and getting me, doing like horrible things to me. I was getting it by hundreds I mean, I probably got like thousands of them in the end altogether. But all these threats, like I still randomly get some, but like horrible things, like emails, text messages, finding like address, knowing you know what I'm saying? It was bad. It is. But I just was like hoping it was all just empty threats and I just didn't do anything about it. But I mean, I know people could be, it could be horrible. So I get it, but you got to go after the people that are threatening, because all the people you guys name, we don't threaten. So I don't know. Oh, thanks, I Jones or L Jones. And most of them probably are just, they aren't going to do anything, at least in my case. But you just never know. Of course, there's a part of me that was like, I hope nobody comes and does anything to my family and talking about my mom needs to die and like for having me and all this stuff. People are evil. When they get behind the keyboard, they think that they could just say anything and there's no accountability, that they could just say whatever and nothing happens. And they can't. The crappy thing is they can and nothing does happen because it is hard. It's hard to make a case. But the biggest thing is with Jessie, like I said, phone calls for prison wasn't trying to defame her. It was more like this case has a lot of different things going on. Now, even the state attorneys, even the prosecutors were interested in the cause and what he was saying because of the case, right? They were pulling him to hear him for the case because it all kind of does. It is all relevant to the case, really, in a way. It's this big story. And it is because she was asking for donations for an appeal for his case. So now there's calls that show this person that's running this fundraiser, that's asking for people's hard-earned money for donations for this guy, to get this appeal. So of course they want to know, like, is this legit? Is this money going towards the right thing? The stuff they auctioning off that we're spending our hard-earned money on, is this like real stuff that we're going to get from them? Like, it does have to do with the case in a way. It does. It all does. It's not, I mean, you could relate all that each thing back to the case. I think like her calls definitely are important to the case because of the appeal and the fundraiser. So like, that's going to be hard, at least her calls. Now, the explicit ones that are on Patreon, maybe those would be a little bit more doable, but like the ones with hers, that's going to be hard to show that has nothing to do with the case, because it does. I'm sorry, it does. She's in charge of that fundraiser, and she's in charge of getting the stuff that people are donating for the appeal of his case. That the funds are to appeal his murder case. So that's going to be hard. I'm sorry, she doesn't got that. That's not going to work. She probably does have other avenues to go, but she's not, that route is not right. Yeah. I mean, I'm not trying to be mean. I'm just trying to, from this, what I know, just my opinion. That's what I think, but who knows? I think it is. And I think it's going to hurt, because now all these women that want to reach out and have this relationship with them, regardless if he's in a relationship with Jessie or not, but because the fact that the phone calls are being released, they'd be scared. But now it's a little bit different, because now he's on death row. He's in a different place, which I don't think those calls are going to be public record. So I guess now people could reach out and probably feel safe that they're not going to be released. But I don't know. I mean, what are you going to do? But that's it. So no, it's Jessie. It's Jessie. It's Jessie, and Wade is the plaintiff. Kelli was just somebody talking like on behalf of, like, supporting Jessie. You got to rewind. It's, if you're talking about me, like what I just went on, no, it's here. Let me show you. It's Jessie and Wade versus Lee County Sheriff's and the State Attorney's Office. The plaintiffs are Jessie and Wade. I should change it and put Jessie and Wade sue. I need to add Wade onto there on the title. But anyway, all right, guys. Well, I'm gonna go. I don't really have anything else. I just wanted to read that for you. Have a good one, everybody. Oh wait, thank you. Oh, Zawowski, you did another one. Thank you. Yeah, I will definitely get back to you. I've just been super busy. I have emails to get back to. I will, though. Thank you. Thanks, Ruth. No, it doesn't say. It doesn't say, no. I know his next hearing is October 16th. He has the I think it's the 16th, if I'm remembering right, for the appeal. I think that's his next hearing, but Wade's for the appeal now. But I don't know if that's going to be televised. I hope. I don't know. Yeah, go. I might go listen too. If there's new calls out, I'm going to go listen. That's what I'll do while I'm researching those other cases. Thanks, Hossein. Thanks, Caroline. Hey, Ashy. Bella Blaze. Yes, I'm going to go check them out. Hey, Liz. Bye, Granny. Bye, Jessica. Trevor. I think she's really scared because she knows what the next calls are going to be. She's probably freaking out because who knows what they talked about. I don't know. But I wonder if there's more scams or something. She's doing everything to get those not released. But why do I have a feeling of whatever already has been given, like whatever prison calls already got the calls? Why do I have a feeling that Lee County or the sheriff's office, probably not the sheriff's office because the state attorney, why do I feel like they probably aren't going to release anymore as far as like anymore? I bet you they won't do any more requests. I just have a feeling just to not have to deal with it. I don't know. I could be wrong, but I don't know because I don't know what she already has prison calls. She might already have a bunch of them. She probably does. She probably got the rest. I bet you she has, since has right now from June and July 24, she probably has the rest of his time because it's only a couple more months of his time from his stay at the Lee County. So the rest will be with Jesse or whatever. I bet. Parallel. Oh, yeah. Hey, Candace. Later, Ilvin. Whose Instagram? Bree? Whose Instagram? I don't know what you mean. No, bye, Chief. Just me. Thank you, Moira. Thank you. Oh, yeah, me too. I am too. Wonder how long is each episode? Is it like an hour or a half hour? I am excited. Menendez brothers, that case really, it's very interesting to me. How many seasons are there? I don't know. We'll talk. I don't know because I don't know how monsters work. Remember, I didn't watch the first one. You'll probably get me hooked. Thanks, Granny. Yeah, I got it, Katara. Bye, Tara. Thanks. I will, Cheryl. Go watch them, guys. Go to Prison Calls and watch her new one. Phone Calls. I guess she just released some. So, I mean, you do whatever you want. I'm not making you do whatever you want. But I guess she just released them if you guys want. I don't know who they're from. Like I said, I haven't even looked. But I'm like, go do this. No. Hey, Stacy. No, I was actually not going to even do a live today. I was going to take a day off from a live, but because this all came out, I had to. I haven't watched any. Sarah was telling me about it, and so I didn't. We're going to watch the Menendez one because I love that case, dude. I spent a lot of time kind of deep diving that case. I did it more personal. I did a few videos, but like privately, that case is so interesting to me. Well, thanks, Rebecca. Yes, I am Darth. I am. I just wanted to read the documents. Kim, it's on Netflix, I guess. Right, Sarah? Netflix? Netflix, Alicia. Yeah, she said actually on that Q&A yesterday, she said it was they quit it, they stopped it. And I wonder if it's because that there is some lawsuits against the Fundly or something, maybe for the scams. Or she's probably having so many issues of people asking for refunds. But yeah, she said the Fundly and the Go Get Fun or whatever it's called. So she must have been behind that too, because she named both of them and said they're both stopped. They stopped them both. So, and then she was talking about in that Q&A, watch my video yesterday, my live last night. She was talking about like trying to find a way for other people to be able to donate for future, because that appellate lawyer, they don't have it. They're still going to cost more than that 90,000 they raised. They're going to have to keep getting funds coming in. So she was talking about like figuring out a way for people to be able to donate to it. But Courtney that was a Wade supporter, now she turned on him. And that's another thing on my live yesterday. I have timestamps on my live yesterday, guys. And all my lives, I mean, most of my lives, I have the timestamps. But in a pinned comment, go check it out. I read the Courtney messages between her and Wade. And yeah, she goes off on him. So she's not a supporter anymore. And she was the one doing those lives like every night, or a lot of, I don't know if it was every night, but she'd do a lot of lives on TikTok with the supporters. So he's losing. I mean, I don't see too many people sticking around, but and that appellate lawyer, I mean, they have to consistently like pay him every month. So I don't know if they're going to be able to afford to keep him, because I don't know what the total cost. I'm going to have to look at the invoice. I don't think they said recurrent payments. They had already spent 85,000, but they have to keep paying every month. I don't know what the total amount's going to be, but he's not. I heard he's a little expensive. Kim, yeah, I am going to. I know. It's 150. Yeah, that's a lot. So they only had not like around 90 some thousand. So they need to come up with another 60,000. And they already, from that invoice, they had already paid him 85,000 around, it looks like, but they have to pay him then every month. So yeah, I don't know. I guess we'll see. Like I said, if I'm remembering right, the next hearing for the appeal is October 16th. I'll keep you updated on this case if I see anything happens with this, with the Jesse stuff. Yeah. Oh yeah. He'll have appeals for years. What do they say? Like 10, 15 years as far as death row appeals. They have like appeal after appeal. But this one, I think what they're trying to do is trying to get like a new trial. Like they're trying to get him off, like not just like off death row, but off like free. Nah. All right, guys, I think my nephew's here. That's right. He was going to come and help us open his gas tank. We can't get it open. We're trying to sell his car, and we've been having problems. We're on the 4th battery. It keeps draining the battery. And we keep it charged. I don't know. We're just having issues. And now Case, my nephew, wants to take it to his homecoming because it's like a pretty cool car. And he wants to take it to homecoming. And so we can't open the gas tank to put gas. So my mom's like, she's taking it in to get the rest of the stuff checked. She's like, well, I can't have you drive it, and then we won't get gas to be able to take it into the shop. So he's trying to figure out how to open it. So I'm going to go talk to him. All right. Bye, guys. Have a good one. See you guys probably tomorrow. I'm sure I'll see you tomorrow. Bye.